afternoon. No, I was just trying to check if all the links take me to the same place. So I'm going to try the third one now, and then I'll see.
What just happened between the three of us is the same.
Good afternoon to you, if you are greeting me.
Good afternoon, everyone.
My goodness.
Good afternoon.
Afternoon.
Your Excellency.
Medimela.
Okay.
Ke tsogile kgaitsedi ya ka, wena o tsogile?
Teng.
Very, very good. O batla mo.
Batlang mo university yaka.
I see. Wonderful. How wonderful to see you.
Of course. This is my university.
Oh.
You can't just be there without me.
I see. Wonderful. Thanks to receive me. You sit where? On council?
We are out of touch, eh?
You must tell me. Yeah, let me I've been talking to the law school. I've not been talking to the whole university. I can't hear you.
I'm saying, what's my Vice Chancellor Bennett?
I see. You're looking for your vice chancellor.
Yes.
Afternoon, Chancellor. Afternoon. Afternoon, Justice Moseneke.
My goodness, Madam Chancellor, am I there? Vice Chancellor, good afternoon.
Afternoon, Justice. Afternoon.
My goodness.
Yes. Thank you so much for making time, Chancellor, for this very important inaugural lecture. Chair.
Yes, they made me drive like mad from my other work to come and be with my eminent brother.
How wonderful to see you, Madam Chancellor. Of course, I would be out of the loop because the university didn't invite me when you inaugurated.
Okay.
Justice, we are still, planning to host the inauguration.
I see.
You're going to receive that invitation. I can guarantee you that.
Okay, I'm ex-chancellor of her university, your Madam Chancellor's university, and she's my blood sister, so I need to be there.
Yes, no, we'll make sure that you're there, Justice. We'll make sure that you're there.
Wonderful.
Yes.
I have an excellent Vice Chancellor in Bennett. I'll tell you more about him when we are not online.
Thank you, Chair.
Okay, then I will have a cup of tea and talk about the wonderful Vice Chancellor.
Yeah, he's attracted so many people to that university. He got my boss just before he started. My boss came to address their Women's Day program and has not stopped talking about the University of Venda. And then all the judges, like Mujapilu tells me, the best lawyers come out of that university now. Moja, have you noticed?
Yes. Those are quite indeed a very, good honor for us. And those such kind of accolades, do come from, very eminent people in the county. And we really appreciate that team.
Absolutely.
Yes.
I'm a guest today as well.
Yes. Chancellor, I needed just to check with the head of the School of Law, Professor Ndovu, if we are about to start.
Good afternoon, ladies and gentlemen, Justice Moseneke, other colleagues, and Chancellor, and our principal. I'm one of the program directors, Van der Walt, from the School of Law, and we are ready to start. Dr. Mailula, my co-program director, has just joined us with his video face as well. I am going to ask that everyone please switch off their video unless they are presenting, just to preserve some bandwidth. We are quite a huge crowd attending today. So once your name is announced and you are speaking, then you can please turn on your video. For the rest of the program, please keep your video switched off. I will just announce one house rule, except for the video to be turned off. We are not going to take questions live. We'll take questions in the chat box when we come to the question and answer session, and the program directors will pose the question to our guest speaker one by one, and we'll use the allotted time for that session, and then when the time is up, unfortunately, we won't take any more questions. I trust everyone will find that in order. And without further ado, let me introduce our Vice Chancellor and Principal, Dr. Ntambaleni.
Thank you, Program Director, Professor Van der Walt and Dr. Mailula. Chancellor of the University of Venda, Advocate Mujanku Gumbi. Chairperson of the University of Venda Council, Mr. Lecheta, and members of Council. Former Deputy Chief Justice of the Constitutional Court, Justice Moseneke. Judge President of the Mpumalanga Division of the High Court, Judge Likhodi. Judge of the Limpopo Local Division, Tando High Court, Judge Patudi, Judge of the Gauteng Division of the High Court and adjunct professor in the School of Law at the University of Venda, Professor Elmarie van der Scheef, Chair of the Department of the Criminal and Procedural Law at the College Law at the University of South Africa, Professor Sorom, Executive and Senior Management of the University of Venda, Executive Dean of the Faculty of Management, Commerce and Law at the University of Venda, Professor Ganyane, Executive Dean of the Faculty of Commerce, Management and Law at the University of Limpopo, Professor Sibanda, Head of the School of Law at the University of Venda, Professor Ndovu, Acting Director of the School of Law at the University of Limpopo, Advocate Rapatsa, representatives from the Amalgamated Lawyers Association, representatives from the Black Lawyers Association, representatives from the Southern Africa Litigation Center, representatives from the International Commission of Jurists, representative from the Africa Judges and Jurists Forum, representative from the National Democratic Institute, University of Venda staff and students, distinguished guests, and ladies and gentlemen. It is such a great pleasure for me to welcome you today at the University of Venda and to our beautiful province of Limpopo. Today marks a very important day in the history of the University of Venda. We have gathered here this afternoon to launch the inaugural Justice Moseneke Lecture. The Justice Moseneke Annual Lecture will now become a permanent event in the University of Venda academic calendar. Program directors, let me take this opportunity to commend the Executive Dean of the Faculty of Management, Commerce and Law, Professor Ganyane, the Head of the School of Law, Professor Ndovu, and the organizing committee for planning this judicious event. The University of Venda, like all other universities in South Africa and elsewhere, we aspire to establish meaningful local, regional, and international linkages. In positioning the University of Venda for impact and relevance, our strategic plan 2021-2025 has put emphasis on 4 interrelated strategic thrusts, namely the student-centeredness and engaged scholarship, the intrapreneurial university, governance for outstanding scholarship, and lastly, linkages, partnerships, and internationalization. Our strategic plan foregrounds these linkages in a simple but very effective way in its quest to be an engaged university. Our view of the university is that universities must be a catalyst for building inclusive societies. Universities should lead the charge in addressing developmental challenges by providing relevant contextualized knowledge, insights, and locally relevant recommendations for policy formulation and implementation, solving existential problems, creating technological products, and producing new knowledge that can be adapted for economic, political, and social improvement. Through the events such as this one, the University of Venda endeavors to foreground its perspective that our core mission is not only the production of graduates who contribute to the national agenda, but a noble role as important contributor to the civic and community engagement. Program directors, our special guest today need no mention. Justice Moseneke is an illustrious jurist of national and international repute, and his contributions to the struggle for the liberation and access to justice are known to many. We are familiar with his work through his judgments and his literary prose, as evidenced by the books he has authored. Hence, it was befitting for the University of Venda School of Law to name this public lecture in his name. We are very excited that as investor vendor, we have such an illustrious jurist associated and partnering with us. Justice Moseneke, we are very familiar with your early work of representing our people whose human rights and dignity had been violated by the apartheid system. And this is happening after your unpleasant sojourn at Robben Island as a political prisoner. We are also familiar with your work at the Native Investment during the formative stage of our democracy. You made us laugh in the Laugh It Off case. We felt shocked by the somber reality of our vulnerability in the life demanding arbitration hearing. On behalf of the Investor Vendor Councillor, Advocate Gumbi, I extend a warm second welcome to you, considering that you launched your book, All Rise Judicial Memo, here in 2020. We look forward to partnering with you, the Faculty of Management, Commerce and Law, and our soon-to-be established the University of Venda School for Legal Practice will benefit immensely from associating with a jurist of your stature. Program Director, I thank you. Considering that you launched your book, All Rise Judicial Memo, here in 2020. We look forward to partnering with you, the Faculty of Management, Commerce and Law, and our soon-to-be established.
Thank you very much, VC, for such warm words of welcome. I think now we can proceed without any waste of time to call upon the next person on the program, the Executive Dean of the Faculty of Management, Commerce and Law, Professor Baraka-Nyani, to also come in and offer a word of welcome. Prof. Kanyani, over to you, please. Thank you.
Thank you, Program Director. I'm very much thankful for this event that is very audacious. It's an event that will be remembered because of its intended outcomes. I take with due diligence as our Vice Chancellor, Dr. Ntambeleni, has already taken us through the protocols, recognizing the esteemed speakers and as well as the esteemed contributors in the field of law. But I just want to recognize the presence of our retired Judge Moseneke, as well as the Judge Legori, the President of Mpumalanga, the Judge Paturi, Judge of Tuyando High Court, as well as the respected members of the community. Ladies and gentlemen, distinguished guests, I want to also echo my voice to state it categorically clear that you will agree with me that it is an honor and a privilege to be addressed by our Judge Moseneke himself at this important lecture, and going forward, knowing that it will be able to increase more robust discourse on issues of common interest. And this lecture comes at the right time when we recently, on Friday, 22nd of October, another monument of history that was made by the university by signing the MAU with the Law Society of South Africa, Legal Education and Development. And we have in that event announced the establishment of the School for Legal Practice and here on campus. And therefore, this series of lectures, which will be kick-started from today going forward every year in October, we will be grappling with issues of social justice. And therefore, the topic today, it is not only topical, the issue of judicial oversight and the separation of powers doctrine is also a controversial subject matter to engage with, but we leave this to our expert, our Justice Moseneke, to be able to unpack it before us so that we can be empowered and engaged in the discourse. So therefore, I want to encourage all of us to engage in a robust discussion today so that we can able to move forward understanding the legality of the matters of this common interest. Without the shadow of doubt, the retired Judge Moseneke is fit for purpose to engage on this important subject matter. UNIVEN is committed to engage scholarship, which involves a community of practice. And as we are all gathered here, we are a community of practice, fulfilling the ambitions of the vision of the university on engaged scholarship. And therefore, this lecture is a testament of this engaged scholarship. I look forward for this discourse that will serve as a historical mark to trigger more debates that are useful to empower the community members in all levels. In the main, this lecture is a classic example of the School of Law advocating for social justice and community engagement. So Justice Moseneke is a symbolic evidence and embodiment of a career giant whom we should follow his pathways. And the students will be able to use him as an exemplar to remain committed to the scholarship in the law faculty. For that, we remain eternally thankful. And with these beautiful words of rendition, I want to welcome all as we engage. Thank you. We should follow his pathways, and the students will.
Thank you very much, Prof. Kanyani, for that introduction. I will now ask our Dean of the School of Law, Prof. Ndlovu, to introduce our guest speaker.
We remain eternally thankful. And with these beautiful words of rendition, I want to welcome all as we engage. Thank you.
Good afternoon, ladies and gentlemen. Good afternoon, program directors. Taryn, I'm not going to be
Thank you very much,
speaker. I'm just going to give a context to this annual lecture.
I will now ask our Dean of the School of Law,
Judge Patudi will do the
Ndlovu,
introduction of the guest
to
speaker.
introduce
I
our
would like
guest
to
speaker.
start off by saying I would want to observe all protocol and, of course, acknowledge the presence of our Chancellor, Advocate Gumbi here, my VC, Dr. Ntambereni, my executive dean, all judges present here with us, our partners from the legal professional bodies and NGO sector, and then, of course, the legal practitioners here present, staff from UNIVEN, and specifically staff from the School of Law and students, and of course, all colleagues that are here. I am quite happy that you have joined us in your numbers for this momentous occasion. Program directors, allow me to extend a special word of welcome and appreciation to our guest speaker, retired Deputy Justice Moseneke. I'm glad, ladies and gentlemen, that you are joining us 3 days after the local government elections. At least I'll be able to catch your attention undivided, with no possibility of emotional and other distractions, because the elections are over. And I'm also sure that I'm not going to address a hung audience. I've been allocated a few minutes to speak, and I will use my time wisely. After Justice Moseneke successfully launched this book, at Univen in 2020, I'm talking about All Rise, the Judicial Memo. We soon thereafter approached him, asking him to have this annual lecture named after him. And he generously accepted to be the speaker on the first lecture and the second one. And then the other condition was that after the second lecture, he will then work with us to identify suitable speakers for the annual lectures as we move along. We have decided to call this first lecture the inaugural lecture, not in strict academic parlance, but simply saying it is inaugural because it is the first. Or if we have wordsmiths amongst us here, they will be talking about the marking the beginning of something or a period. So that's the context in which we are viewing inaugural. Then from 2023 onwards, as I've just hinted, we will then work with Justice Moseneke and identify suitable speakers to grace the occasion. And our plan would be to look at South African judges as also judges in the SADC region and then judges in Africa and the rest of the world. So depending on the theme for the particular year. So ladies and gentlemen, this year's theme, dealing with judicial oversight and the separation of powers, is quite ideal. And I would not want to preempt what Justice Moseneke is going to talk about. Suffice to say that for us as a faculty in the School of Law, these annual lectures will allow us to link with the judiciary and obviously enhance the relations between the School of Law and the other relevant players in the training of legal students, of law students. And we will, in due course, combine the annual lectures with other activities that feed into research, teaching and learning, and the practical training of students. And we hope that judges will come to the party. We do have our networks already with judges and members of the organized profession, and we would want to see, weeks culminating in this lecture. As we go on, we would want to take the lectures with other activities. Everyone anticipates that. We are already, as I speak to you, ladies and gentlemen, we have our own modest linkages with the GP. Every year he comes to lecture to our final year students on a topic of his choosing. Justice Likhodi from the Mpumalanga High Court, the Judge President, also is quite a friend of the school, and he also comes to teach our students from time to time. We would want to cast the net wider and combine such activities with this lecture as we move along. Having said the above brief words, let me take this opportunity to thank the organizing team comprised of the two program directors, Professor Van der Vaart and Dr. Mailula, and then other members, namely Dr. Simbo, Ms. Mopai, Mr. Lubisi, Mr. Tokolo, and Mr. Musekene, for helping us organize this event. I hope, ladies and gentlemen, you will appreciate and enjoy this inaugural lecture. And we hope to see you at the second lecture in October 2022. And we hope that the lecture will be held in person. Thank you very much. Over to you, Program Director, Dr. Mailula, and then other members, namely Dr. Simbo, Ms. Mopai, Mr. Lubisi.
Thank you, Professor Ndlovu, for such a comprehensive and very relevant background and context, relating to the theme of the inaugural lecture. And without a waste of time, I would like to hand over to a very dear friend of the School of Law and the faculty, Judge F. Logodi from the Mpumalanga High Court. Judge Logodi, over to you, please. Thanks. Thank you, Professor Ndlovu, for such a comprehensive and very relevant background and context. My apologies, Justice Paturi, my sincere apologies. Please, you may proceed. Sir. Of time, I would like to hand over to a very dear friend of the School of Law and the faculty, Justice Paturi. You are muted. Will you kindly unmute?
Oh, am I audible now?
Yes, we
Okay,
can hear you.
thank you.
Thank you.
Yes, I was still saying thank you very much, the program directors.
My apologies. Justice Paturi.
Let me first
Please, you may proceed.
thank the Chancellor, Advocate Mujangu Gumbi,
Justice Paturi, you are
and the Vice Chancellor,
kindly unmute.
Professor Mtambili.
Yes, we can hear you. Thank you.
I'm not sure I've got an echo. Where does it come from? Does it come from my side?
Judge, yes, it comes from your side. I see you are logged on as two different users. Maybe you should just log off the one. You are attending from two devices.
And the Vice Chancellor. Is it? Let me check which one it is. Professor Mtambili. I'm not sure I've got it. Is it okay now? Where does it come from?
Yes,
Fine now,
thank
you may proceed, sir.
Judge, yes.
Hello, am I audible now?
You are logged on as two
Loud and clear.
users. Maybe you
Okay,
should just
thank
log
you.
off the
Thank
one.
you. Program directors, as I say,
You are
let
attending
me,
from two
without
devices.
more waste of the time, observe the protocol as it has already been observed. And because I'm now being tasked with this daunting exercise to introduce an esteemed jurist, program directors, ladies and gentlemen, I would, as of now, say, allow me to place on record that members of a certain family in Pretoria joined a principal of a certain school called Dr. W.F. Nkomo Secondary School's convivial celebration on the birth of a boy child sometime in the year 1947 in December. This happened in Pretoria. The boy child at the time attended a primary and secondary school in Pretoria. By the way, the Pretoria is well known as Jacaranda City. And he, this young boy, at the age of 15, when in Standard 8, which as of now is regarded as grade 10, joined what we call Mzabalazo. He was arrested, detained, and tried of participating in anti-apartheid activity. He was convicted and sentenced to 10 years imprisonment, all of which he served on Robben Island. While jailed on Robben Island, he completed his matric, obtained a BA degree majoring in English and political science, a B.Juris degree, and later completed an LLB degree. University of South Africa conferred all 3 degrees. He started his professional career as an attorney's clerk at Clark-Burns Incorporated in Pretoria in the year 1976. He practiced as an attorney until 1983, when he decided to join both the Johannesburg and Pretoria bar as an advocate. 10 years later, in 1993, he was elevated to the status of senior counsel and served on the technical committee that drafted the interim constitution of the Republic of South Africa in 1993. And in 1994, he was appointed the deputy chairperson of the Independent Electoral Commission, which conducted the first democratic elections in South Africa. In November 2001, our guest speaker was appointed a judge of the High Court in the then Transvaal Provincial Division. Now it's known as Gauteng Division, Pretoria. And a year later, he was appointed as judge in the Constitutional Court. In June 2005, he was appointed as the Deputy Chief Justice of the Republic of South Africa, a position he held until his retirement from the court in 2016. Ladies and gentlemen, our guest speaker presented a number of lectures, such as this one today. Among those is Oliver Schreiner Memorial Lecture, where he spoke of separation of powers, democratic ethos, and judicial function. He is the author of two biographical works, one, My Own Liberator, a memoir, and All Rise, a judicial memoir in 2020. Ladies and gentlemen, I'm not certain as to whether to address our guest speaker as an emeritus, as I already heard people saying a retired, because the title emeritus is the one that addresses the former holder of an office who, after having retired, is allowed to retain his or her former title as an honor. But with regard to our guest speaker, he retains the said title even when he is, in quote, retired. Ladies and gentlemen, it is an honor and privilege to usher to you none other than the Honorable Dr. Justice Moseneke. If we were in a hall, I would be saying, all rise. Let me usher to you the Honorable Dr. Justice Moseneke. Over to you, program directors, and to the esteemed leader and jurist, Dr. Justice Moseneke. I thank you.
Thank you very much for that very eloquent introduction, Judge Patudi. Can I ask again, please, all attendees, please switch off your microphones and your video camera so that we have the very best possible quality of our Justice Moseneke's lecture. And Justice, over to you.
Professor van der Walt, I hope I'm clear and loud. And Dr. Mailula, I would like to start by indeed acknowledging and thanking the Chancellor, who has had a lot to do with my own career in ways that I described in detail in All Rise. So it's wonderful to see her as Chancellor of this university. I don't think she knows that I've been connected with the university as much as this. Allow me to go to Vice Chancellor again for the warm welcome. Professor Tambeleni, I will come out there in person, not long to come and visit. I know that acknowledgements should go much beyond this. Allow me to acknowledge my colleagues in the judiciary. Obviously, I am partial. JP Logodi, Tobela, Professor Danisha, Dumedisha. And just like that, indeed, that warm introduction from Judge Patudi, head of court in Venda, I am most grateful. I'm grateful to many people, certainly Executive Dean, Management Commerce and Law, and I must pass on quickly to Professor Lanias Ndlovu, head of school with whom we've had continual contact. And I must say that he and the organizing committee, I must thank. I have prepared, before I go, let me thank the 120 odd people who I see have bothered to be here today, and members of the academy, members of the attorney's profession, advocates profession, members of the broader public, and those who are here present. I've hoped that there would also be students who would be present. Excuse me, I have prepared a text, and I'm going to walk through the text. Like I'm letting you, it is about 17 pages, and therefore it will take about half an hour to read. And as we had arranged with Professor Ndlovu, I'll be available and open to enter into a discussion with those who would care to do so within the time that would be available. I am most thankful, and it is a privilege to have an annual lecture as this one. I'm overjoyed. I'm starting to deal with the text now by the initiative of the School of Law to inaugurate this annual lecture. Annual lecture series will, of course, create space to engage in rigorous, if not robust, conversations about the elusive intersection between law, justice, and society. In agreeing to deliver this lecture, I committed to address the extent and the limits of judicial oversight over executive functions in light of separation of powers doctrine. I'm not unaware of the quiet work of the law school in putting together this special occasion. As I said earlier, I'm equally thankful that so many from the university community address the extent and the limits of judicial oversight over executive functions in light of separation of powers. Post and undergraduate students have made time to attend this lecture. I've already acknowledged the judge president, judges here present, the magistracy. I am grateful for that. This afternoon, I am minded exploring a perennial, in other words, unending, if not intractable conversation on the shifting boundaries between the judicial and executive functions of our state. It is commonplace that the judiciary and the executive government are arms of the state. They are deployed, that now famous word, to achieve constitutional ends. The public power each wills derives from our supreme law. Our basic law confers on each far-reaching but intrinsically different genres of public power. Both arms are bound by and are obliged to exercise only the public functions and within the limits that the Constitution permits. There are, of course, powers which are only the judiciary may exercise, and there are other powers which only the executive may perform. However, there are judicial and executive functions which intersect to create checks and balances against an overconcentration or abuse of power and to exact accountability. In some instances, as we'll see later in this lecture, the exercise of judicial and executive function may be qualified or limited by self-restraint on the part of the judiciary or on the part of the executive to avoid breaching the terrain of another arm of the state. It may be added that the constitutional text, which confers functions to the judiciary and the executive, is open-ended and may sometimes be capable of more than one plausible meaning. For all these reasons, the boundaries of judicial and executive functions are not always clear. In practice, they are subject of ongoing contestation. On occasion, the judiciary and elements of civil society would point to perceived executive interference with the judicial function. On the other hand, the executive may complain about judicial trespass into executive terrain. However, at the edges, the boundaries do shift and they are not cast in constitutional stone. Recent events in our embryonic constitutional democracy have yielded stark illustrations of this contestation, albeit sometimes unwittingly, in the exercise of judicial power on the one end and executive power on the other end. The question must be asked whether in instances of great social or political contents that take the form of litigation, there's an emerging consensus within the broader community about the legitimacy of the way judicial power is exercised. This lecture, therefore, seeks to explore these shifting boundaries of public power and of public perceptions of the judiciary by drawing lessons from the recent past. But before I do so, I give you a very brief historical context. The law has played a very important part in our history. Apartheid oppression was itself a collection of laws which were harnessed to achieve unjust economic and political ends. The government, its security apparatus, and courts were obliged by law of a sovereign minority parliament to give effect to apartheid and colonial designs. And just as the system was, it always hankered for a veneer of the rule of law. However, in the eyes of most people, there was no real divide between law and politics. Law served the narrow political ends, and courts were seen as mere instruments of repression and oppression. In the process, their legitimacy suffered and waned. For that reason, opponents of the settler and apartheid regime were suppressed and sometimes prosecuted in courts through the law. Activists too used courts and the law to proclaim their cause. This point is made rather sharply by an instructive article by Dennis Davis and Michel Leroux in Precedent and Possibilities. And I quote the observation: during the long night of apartheid, courts were often sites of vigorous political struggle, being places where different visions of the country were presented to the public by competing litigants, usually the state against accused persons or applicants whose rights were at stake. Since 1994, and at the advent of constitutional democracy, similarly, significant contests have taken place in the courts. There is, however, a major difference. Litigation now takes place within the context of the Constitution, which provide a vast range of rights for all who live in the country. the code ends there. I continue that major difference is the advent of constitutional democracy, which was forged on the anvil of division and past injustice and economic inequality. The Constitution does not only intend to establish its supremacy, rule of law, and fundamental rights, but also recites our collective convictions. It contains our most recent and joint ideological and normative choices of what a good society should be. It enjoins all to take reasonable steps without undue delay to achieve a good society. The virtuous society envisioned by the Constitution and hoped for by it has a significant social democratic flavor. It means to protect and advance fair labor practice. It compels all to preserve an environment that is not harmful for the benefit of present and future generations. It does not permit arbitrary deprivation of property, a much contested matter, but permits expropriation and redistribution of land for public good if it is against a just and equitable compensation. So that envisioned society, thought of in 1994, was meant to set itself firmly against poverty, against ill health, and against ignorance. This the Constitution does by promising everyone the right to have access to adequate housing, health care, food, water, and social security, subject to available resources and progressive realization. Our Constitution then had hoped that a child's best interest would be of paramount importance in every matter concerning it. It promised then everyone the right to basic education, including adult basic education. That what is more, in our constitutional arrangement, we all were promised of our ideal society, or were promised in our ideal society that all these rights would be justiciable before the courts. It follows from what I've said that the tenets of our constitutional democracy, adopted in 1994, were meant to be the most reasonable, reliable social consciousness on what a fully transformed society should look like. And therefore, the elusive question is not whether there is a social consensus, but whether the internal boundaries between judicial and executive functions are properly suited to deepening democracy through the constitutional project. To understand better the boundaries, we must first examine the way our Constitution apportions public power. The principal public instrument for the reconstruction of our society was meant to be the state and its organs. The Constitution makes no express provision for separation of powers. It is, however, self-evident from its architecture and dispersal of public power, or the apportionment of public powers, that the Constitution creates a separate legislative, executive, and judicial functions. In Parliament and provincial legislatures vests the law-making authority. The executive authority vests in the president, who exercise it together with members of the cabinet. Judicial authority vests in the courts. So while the Constitution doesn't have a word like separation of powers, its architecture points to and inducts the doctrine of separation of powers. And in fact, in the first certification judgment of 1996, the Constitutional Court in this regard observed there is, however, no universal model of separation of powers. And a democratic system of government in which checks and balances result in the imposition of restraint by one branch of government upon another, there is no separation that is absolute. The Constitutional Court then, in the very early days, 1995, continued. The principle of separation of powers on the one hand recognizes the functional independence of branches of government. On the other hand, the principle of checks and balances focus on the desirability of ensuring that the constitutional order as a totality prevents branches of government from usurping power from one another. In this sense, it anticipates that the necessary or unavoidable intrusion of one branch on the terrain of another. No constitutional scheme can reflect a complete separation, and the scheme is always one of partial separation. These sentiments were repeated, of course, by the Constitutional Court later in Doctors for Life, where the court said the structure of the provisions entrusting and separating powers between legislative, executive, and judicial branches reflect the concept of separation of powers. The principle has important consequences for the way in which the institution by which power can be exercised. Courts must be conscious of the vital limits on judicial authority. And the Constitution is designed to leave certain matters to other branches of government. They too must observe constitutional limits of their authority. This means that the judiciary should not interfere in the process of other branches of government unless to do so is mandated by the Constitution. I continue, it is indeed so that there is no universal model of separation of powers in a constitutional democracy. Correctly so, our courts are developing a distinctively South African design of separation of powers. It must be a design which, in the first instance, is in harmony with our Constitution itself. On occasion, Professor Vail tried to distinguish three elements in the doctrine. The first element is the distinction of legislative, executive, and judicial functions of the state, something we've just talked about. The second element is the separation of agencies in a way that creates autonomous centers of power that will develop an institutional interest and thereby being checked internally. And the third, which is quite important, is the separation of personnel, of persons, in a way that there are three branches and are composed of separate and distinct groups of people with no overlapping membership. In other words, judges don't become members of parliament, members of parliament don't become judges, and in turn, members of the executive don't become any of the other, certainly don't become members of the judiciary. These three elements are often seen as the negative methods of checking arbitrary rule. In my view, our model of separation of powers must also recognize that constitutional adjudication has far-reaching impact on the manner in which the country should be governed in all spheres and at all levels. Judges, I emphasize, are obliged to decide on disputes with and between organs of states. The Constitution tells them so. To decide decisions on the validity of executive decisions and conduct. The Constitution enjoins them to pronounce on constitutional validity of legislation. Constitutional challenges related to elections and amendments of the Constitution. All of these matters judges don't choose. The Constitution requires them to decide. All of these matters, of course, have political implications in the sense that they relate to the conduct of politically elected or appointed executive or legislative functionaries. It is thus self-evident that conflict between the judiciary and the executive or the legislature on the current architecture of the Constitution is inevitable. This contestation, however, has been foreshadowed by the Constitution. And the Constitution seems to make an express election in resolving the inevitable political implications of judicial activity. It provides that courts are independent and subject only to the Constitution and the law. It is crucial to emphasize that courts are bound by the democratic will of the people, provided it's expressed in legislative instruments that are constitutionally compliant. Courts may not depart from valid legislation. They are bound by it. Executive decisions or policy in preference for their own worldview, they must apply the law impartially, provided it is constitutionally compliant. The Constitution requires that no person or organ of state may interfere with the functioning of the courts. If anything, they must assist and protect courts and, importantly, obey their final decisions if we are all to have peace. This is, however, not the end of the matter. Our model of separation of powers must strike a balance between the rigorous judicial review on the one hand, which I've just described, and the historic need for effective executive government to pursue reconstruction and development of society. The balance must be struck without relinquishing the rule of law requirement that all public power must be sourced from the law. Our system of separation of powers must give due deference to the popular will as expressed legislatively or through executive decisions and policies, provided that the laws, decisions, and policies are consistent with constitutional dictates. If they are not, of course, it would be anarchy. This observation is prompted in part by the counter-majoritarian dilemma. Judges are not elected democratically, and yet the Constitution itself, in other words, the people themselves, entrust them with authority to invalidate any law or conduct that is unconstitutional. This authority to upset legislative or executive choice must be exercised by judges sparingly and in clear cases of unconstitutionality. They don't constitute a blank check. The judicial officer must decide according to the facts and the law, not according to their subjective predilection. A judge must put any party political loyalties behind her or him on elevation to the bench. Experience teaches that judges worthy of that office and title actually do so. And above all, a decision on the unconstitutionality of the conduct of another arm of a state must be clear, strongly motivated, and accurate on the nature and the extent of the impugned unconstitutional conduct. That is a matter of accountability. The judiciary must explain itself when it exercises power so vast. Under apartheid oppression, the judiciary had no legitimacy in the eyes of the disenfranchised majority. Despite that backdrop, our constitutional democracy, which requires us to build a bridge from an evil past to a just society, has given our judiciary powers of judicial review. In effect, it has installed the judiciary as a final arbiter and a forum that will give full voice to our constitutional norm. However, questions have been raised on whether in its rulings, the judiciary is being accepted as credible in the eyes of the public. And Professor Max du Plessis raises the legitimacy dilemma sharply in a journal article entitled Constitutional Court and Public Opinion. He observes, to strengthen respect for human rights under the Constitution, the court is expected to be fearless in upholding rights in the sway of public opinion. But on the other hand, to ignore public opinion, the Constitutional Court runs the risk of being labeled undemocratic and illegitimate. The essence of this dilemma, Professor du Plessis raises, is that courts are duty-bound to give effect to the Constitution in order to transform society. However, if their judgments are substantially at odds with the dominant political and social views of society, they may lose respectability they so sorely need in order to perform their function well. Lessons from the recent jurisprudential past suggest that there is no one correct answer to the question posed. As I near the end of this lecture, I turn now to a few cases that highlight the inevitable tug of war at the one level between the executive and judicial activity, and at another level between judicial decisions and the dominant political and social outlook. Let's go for it. Lessons from the recent past. I look first at the decision of the Constitutional Court, which you all very well know, and that may very well be at odds with popular sentiment. In the death penalty case, State versus Makwenyane, the court took a strident stance that when it interprets the Bill of Rights, it will not resort to head counting as a reliable means of substantive reasoning. In essence, the court took the view that when it protects individual right, it does not do so even against the clamor of public opinion. We know that the Makwenyane decision was met with angry response from retentionist lobby, which frequently pointed to the rise in crime rates and alarming increase in atrocious crimes of violence. Those clamors are still present up to this day. Many have argued that the court has failed to reckon with the political character implications of its judicial activity by banishing the capital punishment. And often the following statement by Krigla J is called to question. In response to this criticism, this is what Krigla J said. I quote, "The issue is not whether I favor the retention or the abolition of the death penalty. No, whether this court, parliament, or even overwhelming public opinion supports the one view or the other. The question is what the Constitution says about it." It was really saying, I don't have to decide on popular view, but rather on what the Constitution says. In a collection of decisions, the court has struck down a series of laws which discriminate unfairly against gay and lesbians. In another decision, the court held that gays and lesbians had the right to enter into a union akin to marriage. There is no gainsaying the fact that gays and lesbians have faced the brunt of social prejudice in this country and elsewhere for centuries. The public mindset has not changed much. However, the jurisprudential stance of the court, and correctly so, is that fundamental rights are meant to provide a dike against the sea of popular prejudice, provided that the Constitution requires the court to do so. The solutions may very well be to amend the Constitution rather than to require the courts to respond to popular conviction, which in a diverse society such as ours may very well provide partisan and accurate diagnosis. In the terrain of indigenous law, you will remember the court has on good few occasions adapted the rules tainted by patriarchy in order to give effect to gender equality and dignity to women in support of the dignity dictates of the Constitution. Many steeped in indigenous tradition would support and protect the rule that adult male offspring are entitled to all inheritance and status within the family. Some may support the rule that says that women may never be traditional leaders. However, a mere public clamor for retention of this patriarchal arrangement ought not to weigh heavier than the express dictates of the Constitution to obtain equal worth for both men and women. In conclusion on this aspect, it must be emphasized that the court is not alien to, but part of the democratic ethos and project that the Constitution puts in place. Judges don't operate in a vacuum and outside the quests for a changed and just society. Judiciary must operate fully conscious of the dilemma that confronts it. It must give effect to the democratic will of the people, as expressed in the Constitution and other legislation. The judiciary must remain alive to the collective mindset of the people over which it presides. It must find that careful balance between the dictates of the Constitution and public opinion that may be properly had regard to in resolving the contested social or political claims. On the other side of the scale, there are cases which some writers call lawfare. Perhaps foremost of those thinkers will be Jean and Jean Kamarov. And lawfare is described as follows. Politics, and I quote, politics in many societies is played out more in the courts than in the streets, more by the use of law, and is disguised violence than by unfettered brutal force. Absent of any legal constraints, in an age of constitutionalism and a dominant discourse of human rights, conflicts once joined in parliament by means of street protests, mass demonstrations, and media campaigns through labor strike, boycotts and blockades and other instruments of assertion, tend now more and more, if not only, in just the same way everywhere, they find their way to the judiciary. Lastly, class struggles seem to have metamorphosed into class action. The code ends there. Of course, the layman's understanding of all this is political warfare that converts into legal warfare. In the last 27 years, our society has had a fair share of political contestations that have played themselves out in our courts and in the Constitutional Court in particular. There is no prize for guessing which cases I'm referring to. You read about them every day, and you continue to read about them every day, and you see them on your television every other night. Our court, as you will remember, the Constitution. 27 years, our society has had a fair share of political contestations that have played themselves out in our courts and in the Constitution. On the fate of Shabir Sheikh, there is no prize for guessing. On the case of Billy Masetla, when his term as Director General of Intelligence was brought to an abrupt halt. On the bid of Hugh Glanniston to prevent the disbanding of the unit popularly known as the Scorpions. On the application of former President Thabo Mbeki shortly after he had been recalled from his position as president. On the legion of court cases and appeals and applications brought by former President Jacob Zuma over 10 years and more. On the right of foreign-based South Africans to cast their vote where they live. On the right of inmates in a correctional facility to vote in every election. On reviewing public protector findings on executive management. On the role of Parliament in relation to motions of no confidence in the President, on the conduct of the President in relation to donations from private sources to fight party elections within his own party, on our executive government executing an ICC, International Criminal Court warrant of arrest against the visiting head of state, President al-Bashir, on contestations within political parties, on so-called step-aside rules and other internal disputes, on challenging the validity of findings of commissions of inquiry. There are many, only two come to mind. Think of the Seriti Commission and the Zondo Commission. In all these cases, and many more, the elephant in the room has been how far should judicial oversight run? Lawfare is inevitably open cost to potential political criticism because the law is engaged to pursue battles that belong properly in the hinterland of political and sometimes religious contestations. Remember, even churches come to courts to fight religious and institutional battles. And given the limited space I have today, I will not in this lecture venture an opinion on the appropriateness of lawfare. In other words, whether citizens are entitled to take their political woes into the courtroom. But on balance, judicial resolution of the gravest conflict must rank higher and better than violent and unlawful methods of self-help. Lastly, in recent times, the court has had to mediate increasing conflict between the state and its citizens on matters that may loosely be described as service delivery issues. We've had to make determinations on access to water, sewage and electricity, on education in the language of one's choice, on arbitrary evictions, on access to electricity by tenants. In each of these cases, entrenched socioeconomic rights were invoked and quite often were found to have been transgressed quite blatantly. The court was well alive to the importance of allowing the executive a margin of appreciation in the execution of their constitutional duty. But that duty includes to diminish poverty, to facilitate a better life for all. And courts are often called upon to police even that. However, there has been blatant violation of socioeconomic rights in issue. Claims of citizen consent have been upheld by the courts, have been violated by the executive arm of state. That is a terrain for inevitable conflict between the judiciary that is pro-poor and an executive that doesn't properly care for fundamental socioeconomic rights of its people. My next title reads Conclusion, which is a signal that I'm coming to the end. Ours is a complex project to entrench democracy, to change our society, and achieve social justice. The executive, so too the courts, are Siamese partners. Whilst their roles in the democratic project are defined with some measure of precision in the Constitution, its text, as I've alluded earlier, is open-ended and in effect creates shifting boundaries. What is required of us is to display the highest possible level of sensitivity, fidelity, keeping at all times the genuine need to create that open, transformed, caring, and socially just society. Courts cannot and may not do all the weight lifting. They have neither the means nor the resources, nor the power that the executive has. We all will do well to remember that the highest form of accountability of the executive function is not before the judiciary, but rather it is before the democratic will of the people. Similarly, the most competent claim for social justice, transformation, including environmental justice, is not from the courts and should not be ordered by the courts, but rather it is through popular and collective agency. It is before the democratic will of the people. Similarly, the most competent claim for social justice, transformation, including environment.
Thank you very much, Emeritus Chief Justice Moseneke Moseneke. You know, I think we all have, enjoyed thoroughly your lecture. You've touched on all the themes, that are, connected to separation of powers, the fact that it is not absolute, the fact that it is not explicitly stated in the Constitution, but can actually be, determined from the structure of the Constitution. And this is the time, Chief Justice, that we offer our participants and our audience an opportunity to actually engage, in terms of questions and comments. And as we indicated at the beginning, we are going to take questions and comments that are in the chat box first. And if we still have time, we are going to engage one or two questions, verbally as well. So I'm going to read the first question so that the Chief Justice can perhaps, I'm going to read, I think, at least 3 questions, and the Chief Justice can then engage with those 3. And then my co-program director will take over with more questions. The first question comes from our own Professor Anthony Nwafor, and it reads as follows. Can there be a separation of powers and judicial independence where the Chief Justice of the country is appointed by the President of the country, who is the head of the executive arm of government? That's the first question from Prof. Nwafor. And there is a second question from Simangele Deisi Mavundla, which reads as follows. How can we prepare a standoff between a political leader and the court? This is in relation to former President Zuma's interaction with the courts. I hope that I am not too fast for the Chief Justice to actually capture the questions. I will read now the third question, with your permission, from Anthea Lee September van Havel, and it reads as follows. This is actually, this is just a comment. I'm going to skip it and go to a question from Musima Jane Rasemula, which reads as follows. The jurisprudence is replete with instances where the executive evoked limitations with regards to the provisions of socio-economic rights, water, housing, etc., in Grootboom, in Sitole, Abahlali baseMjondolo, and others. Are we not seeing a situation consistently where the executive makes choices only with political and economic factors in mind, and not consideration of constitutional ideals and human rights? Does this not consistently place the judiciary to be bound to seem at odds, since their most basic basis is constitution and laws, and not pragmatic considerations in economics rather, and politics? Thank you. Over to you, Chief Justice. I'm not sure. Do we seem to have lost the Chief Justice?
Yeah, let me call him.
Right, thank you. So our participants, you are still encouraged to post more questions in the chat box if you have, particularly our students. I've seen quite a number of students in attendance. Please post your questions, but indicate, that you are a student and at what level of study you are. Thank you.
The program director, I can't reach him on the phone. I suspect he switched it off for this lecture. And maybe he will connect. Sure, what's up.
I think he's trying to connect. Let's see.
I'm here. I can hear you. Are you sure I'm not connected?
You are connected indeed, Chief Justice.
Okay, I think I am connected. I can hear you well, and I can. let me try and answer the questions quickly. The first one is, the manner in which the Chief Justice is appointed is part of the checks and balances that the constitutions try to create. Am I still audible? Can you hear me?
Loud and clear, thank you.
Thank you. It is a method, checks and balances. In other words, the judiciary can't appoint itself. It is the executive that was chosen to appoint the president and the Chief Justice and the Deputy Chief Justice, subject to a process. So inevitably, somebody must appoint the Chief Justice. And I think it's quite in order, actually, I think, that the president be that person as head of state overall, over all the other three arms of state. That's the number one citizen. The real question must be, how should the president act in doing so? And we trust and hope he would act, firstly, lawfully. He would appoint and choose for a valid motive and reason, and would have regard to issues that are obvious and important, like competence, like experience, like patriotism. The judge should be patriotic, should love his country and his people, like being a scholar, providing intellectual leadership, like knowing the law, and being committed to the project of the country, which really is to make it a better place and to transform it. So the president must do the right thing. And the law requires him to consult with leaders of other political parties, and also to submit the candidate to the Judicial Services Commission. And some of you can remember some of those interviews. So whoever will be nominated will have to go to an interview. I know I went to an interview when I was appointed nominated Deputy Chief Justice by President Mbeki, and others tested whether I was good or bad for the job. So there is some safeguard, and I think the arrangement is quite in order. And the independence of the judiciary, if the president acts properly, should not be compromised. The second question is, how did it happen that there would be a fallout between a former president and the courts? Of course, one can follow and look at the actual steps that occurred there. Let me start off by saying it's most unfortunate. We shouldn't be having such an incident in any country. People who are retired and you have served the public continue to be useful, provided they don't run foul of the norms of the society they served earlier. So that really was unfortunate. I don't want to get to the merits of the legalities because I wasn't there and I didn't sit in the court. But ordinarily, we should not end up where we did. And it's quite vital that leaders should be exemplary in many ways. So too courts, as you know, you've heard my lecture. Socioeconomic rights are a perennial problem. Your argument appears to be the one that says that there should be no entrenched socioeconomic rights. And I think that is a wrong argument. I think the executive must do its work and comply with the dictates of the Constitution. Jurisprudence says that if there are genuine limitations, and which are progressive realization and availability of resources, those are the two key limitations, then the executive must produce a plan, remember Groot-Brom jurisprudence, which demonstrate when will they deal with the issue. We know 27 years later, there's no plan to give many communities water. There's no proper plan. And if there is, it has not been implemented faithfully to provide housing. So the law does not require instant gratification or magic, but it requires a systematic, devoted plan to produce and to meet socioeconomic entitlements. And that is why it is subject to available resources and economic realization. I think it's a good thing to have. It's a target. And as I said at the end of my lecture, if the target is not met, the people ultimately will respond, and they will make their displeasure known. Thanks.
Thank you very much, Justice. The following question comes from Howard Chitimira, and he asks, there have been some allegations of judicial capture in South Africa. In light of these allegations, how robust is the doctrine of separation of powers enforced in South Africa? And is our judiciary really independent in light of the recent judicial and political events, again involving former President Zuma?
Of course, allegations which are broad-ended about judicial capture help nobody. Similarly, allegations of political capture or any other broad-based claims are often quite confounding. Every time we talk about judicial capture, I've said to many, just roll it out. Tell us who are the judges. Tell us where, when, how much. Tell us what is the conduct that demonstrates judicial capture. That's the only way you can deal with it. No judge should be captured. And quite often when people are dissatisfied, they throw generic mud. They paint everybody and say there is, even if they target individuals, then they must roll out the allegations and establish them. Let me tell you, I was not immune to that myself at the time when I said, as Chief Justice under a certain precedent, there was a suggestion that I was receiving money from the CIA. And my simple answer was, oh, give me the account number, please. Let me go and get the money if it's due to me. So it doesn't help. It's open-ended political talk, and I don't think we should lightly go down that route. And it's true also of the executive. If you accuse people, you must be able to demonstrate the points that you make. Otherwise, you subvert our institutions. You suggest everybody is polluted, every well is polluted, everybody is rotten. Every judge should not be trusted. We can't go down that route. Every executive actor should not be trusted. I don't think we should go down that route. If the allegations, they must be investigated carefully and outcomes must be made. And if a particular judgment is wrong, I think you must go straight to it and demonstrate that it is wrong. Write about it. Talk about it over the radio and show that it is wrong. That's a better route, I think. Otherwise, all of us will be sitting in a corner and saying, damn, we're all equally rotten. We're all equally captured. And it's not going to help anybody. I think, by and large, judges do their damnness to be independent and to be honest. Do they sometimes get the law wrong? Yes. And that is why in our system, we have an appellate system. If you're unhappy with the magistrate, you could go up to the High Court. From the High Court, one judge, you go to 3 judges in the High Court. If you're unhappy with that, you go to 5 judges in the Supreme Court of Appeal. If you're unhappy with that, you go to 11 judges in the Constitutional Court. And that hierarchy has been done intentionally to reduce the margin of error or the margin of dishonesty. In the Constitutional Court, you must bribe 11 judges. I want to suggest to you that it will be very difficult. The Supreme Court of Appeal, you must bribe 5 judges. All 5 of them must hate the same accused or litigant. I think the system is trying to act like a sieve and try and keep out that kind of error or prejudice. I'm done, thank you.
Thank you so much, Tate Moseneke. I've just got I don't know, am I audible, Judge?
You are audible indeed. Thank
you so much. Wale Kevin Portuna.
Oh, okay.
Yes.
Thank you so
can
much
I
for this.
just interject? Can I interject? We will take a few hands after we read the questions and comments on the chat. Can you live with it? Is that acceptable to you, Tate Poto?
Yes, it's acceptable indeed.
Thank you very much. Thank you very much. I'm going to read the next question. It reads as follows. It's from Musima Jane Rase Semula. And it reads as follows. What are Tate Moseneke's thoughts on the colonial thought and the ideas of scholars such as Professor Joel Mudiri and Dr. Tsepo Madlingosi, who either point to problems with the ideological and normative liberal postures of the Constitution, or how they propose that we should have opted for a Sobukwe type of constitution that prioritizes the people's own articulation of a constitution and not an assembly like we had. This with peri-urban poverty in mind. Over to you, Chief Justice.
Dr. Musima, I don't know whether I should say doctor, professor, or Mr. It doesn't really matter. It's a very fundamental question you ask. As you would know, I'm very familiar with that discourse, and I've been part of it more lately. And I have hosted both Professor Tsepo Madlingosi and Professor Mudiri, only in fact a few days ago, to have a continued discussion. Their disposition is critical of the transition and its efficacy to migrate us from a troubled colonial past to a society that would be capable of the fundamental liberties and freedoms and social change that most people would require. And I know that that particular criticism goes to whether we have established a post-coloniality that will be able to produce certain outcomes. If you say to me there are features of the Constitution which are neoliberal, I understand that. To say that is all that it is, I think it is an overstatement. And I'm currently engaged both of them with a suggestion that they formulate a comparator. You've heard in my lecture, I think certain aspects of our Constitution have a social democratic turn. In a neoliberal constitution, you're not going to find a deep concern about protection around social vital interests of people, such as water and health, and they're all regulated within a capitalist arrangement. In our case, they are located within part of the legislative and executive duty. So the criticism is valid in certain measures, to the extent that it goes, and it is valid that the transition could have been different. I think the critical part, and both of them know my stance on this, has been, let's generate a comparator. Let's generate what it would look like had post-coloniality been of a kind which is ideal to Africanist thought. When we are there, then we'll have the benefit of saying, this is what we have, and this is what it should be. In other words, beyond a theoretical criticism. You know that I've published a number of papers that talk, for instance, about the land question, about the tardiness and the near complete failure of the current government to tackle land justice issues. That is plainly so, it is so. And I've said to Professor Madlingozi and Professor Mudiri, we should also debate whether we're collapsing the woes of a failed state, an incompetent state, with the jurisprudential challenges of a transition that is very committed to uprooting colonial tentacles. In other words, I don't know if that is clear. I'm saying it is quite important not to collapse systemic failure or a failed developmental stage with what the transition should look like. And all those should be examined quite carefully. So in short, I think they make brilliant points of criticism. I think the transition could have been different in certain ways, but I don't think there are absolutes here. I think there are certain things that actually were valuable and are valuable in the transition that we've gone through. Is it perfect? No. Then our task as activists, members of the academy, we should be saying, this is how we think it could look like if it's done properly. That will advance the debate much more. Thanks.
Thank you very much, Justice. Our next question comes from Advocate Hubert. And the question is, the origin of law is derived from boni mores, the public opinion, the moral or legal conviction of society. As the supreme law, the Constitution can, however, override that which is the public opinion, as rightly pointed out and cited in the Makwanyane decision. What then remains the true or effective value of public opinion if it can be negated by the Constitution? Does public opinion still have a role to play in legal jurisprudence? And if so, to what degree?
Yeah, well, thank you. There is an interesting question. As you've seen, the Constitutional Court has taken the route, of course, of overriding boni mores in instances where it is found not to be consistent with the constitutional ethos. An example would be, as I've given a number of examples, the death penalty, excluding people because they're women or gay or whatever else, and so on. So that boni mores is overridden all the time by the constitutional ethos because the Constitution is supreme law. So that is proper and good law. But where boni mores, an example comes to mind, Ubuntu, can actually be used and harnessed to be able to enrich our understanding of the kind of society we want to create, then it's useful. So there is no one size which fits all. There are certain opinions which really are not going to be helpful, and there is boni mores and public opinion that tends to be fed into legal reasoning, but in development of the law, like indigenous law, private law, and indeed in understanding our constitutional obligations. So I don't think it is clear-cut in the sense that always boni mores is not useful. I've given you examples where boni mores, in fact, is, and public opinion could be useful, and it can be worked into our legal reasoning. That's the point. I am done, thank you.
Thank you, Chief Justice. I'm going to read the next question. It comes from Patrick my way through. It reads as follows: Justice, I'm a master's student, potentially a PhD candidate in 2022. I'm quite interested in the field of jurisprudence and how it seems to be overly overlooked in the discussion of a functional legal system. I would like to know what your opinion is regarding a growing point of legal discourse analogous to the notion that during any legal proceedings before a court, it is a judge or presiding officer who is on trial. Thank you.
Yes, interesting. I think it is a nice aphorism, which really says that the judge is on the spot, and that must be correct, except that the judge doesn't run the risk, of course, of an adverse order immediately, maybe on appeal. But you see, that jurisprudential view points to just the centrality of mediating dispute and differences within society. And that's what judges are called to.
Chief Justice, it looks like we're losing you.
Yes, I am back. Am I with you now?
You are audible. Thank you.
Yes, thank you. What I'm saying is that quite often when I talk to exemplify the point you've just made about the judge being on trial, think about a moment when every time a referee blows a whistle for a penalty or a red card, half the people in the stadium will be pillaring that referee, right? Swearing, screaming, and the other half would be cheering and cheering the referee on. And every second the referee makes a decision, all the attention comes not from the contestants, but onto the referee. A judge is, in very uncomplicated terms, that's exactly how a judge is located or situated within a dispute. And that explains why judicial accountability becomes so vital in a notion of dispensing justice. Judges, not only do they have to do all the good things that you require in a hearing, at the end of it all, they must sit down and tell us all how they come to the decision that they prefer. The referees are lucky they don't even have to do that, but judges always have to do that. So yes, judges would be on the spot. They would be subject to scrutiny. And in that sense, yes, they would be on trial. And every single day judges do, and you see that lots on the news, are magistracy, which has been wonderful in many ways. You see them all the time, right through the pandemic, doing their work and being there, present and making decisions, even when everybody outside the court screams that they do one thing or the other. So in short, yes, judges are always on trial. Just like a referee in a match is always on trial. Every decision is open to scrutiny.
Thank you, Justice Moseneke. Our next question comes from Silas Mokhonyana, and I'm going to paraphrase a bit. The question relates to the service delivery protest that we had in July, and the question is, the service delivery protest resulted in the death of protesters and the police, and some of who are now facing court cases, criminal cases for their conduct. But the question then goes on to say, how do you relate the conduct of the police who represents the executive in response to service delivery protests, and now they became the targets of criminal activities?
Thank you. I think the answer is never easy. It's always difficult. Like life, it's complicated. But you see, police, women and men too, must act lawfully. the fact that there are riots, there's no license for them to act beyond what is reasonably necessary to protect life and property. It's a long-established principle in our law. When police come to your home and they knock and they want to arrest somebody, unless certain level of urgency, for instance, they must get a warrant. They must behave in a way that the law requires of them. So police are necessary, are important, but when they act, they have to act in accordance with the law. I'm not saying these did not, and I'm not saying, and maybe that protests were of such a nature that the police had to act in a particular way. I'm making the broader principle. All of us have to act lawfully, and all of us should be subject to accountability ex post facto, after the fact. So it's quite, citizens are entitled, prosecution should ensue if police have acted criminally, wrongfully, and civil liability should ensue if somebody has been harmed or hurt or killed as a result. Thank you.
Thank you, Chief Justice. The next question comes from Felix Dube, and it reads as follows. There are some who say that a traditional understanding of the doctrine of separation of powers does not properly reflect the South African constitutional setting, in that the powers and authority of the Constitutional Court places it up way above Parliament and the executive, and that the court is at the apex of law and politics. Will Justice Moseneke agree with the proposition that perhaps we need to ask if we have a separation of powers or an institutional supremacy of the Constitutional Court? Thank you. Over to you.
Yes, I agree that you heard me say in my lecture, our notion of separation of powers should be indigenous. So I agree with you, we don't have to look at a traditional notion. And the courts have been trying to draw the lines all the time. And in fact, the more prominent cases, of course, sometimes suggest judicial supremacy, but I don't know about it. You know how many cases there are where the courts have just simply refused to interfere with executive power. The more obvious and prominent ones are where the court does interfere, and that gets reported on, and of course, political actors would often complain about that. I've said the boundaries are difficult to find, and you therefore have to go back to the Constitution itself. You remember me saying that maybe the solution is then to amend the Constitution itself. You see, your Constitution says that the court must pronounce on validity of executive conduct. It must pronounce on the validity of laws. It must, in the words of the Constitution, all law and conduct that is inconsistent with the Constitution is invalid. So it may be that we must go back and revise the structures, and that debate is a legitimate one. So in short, you are asking a legitimate question. So we'll have to devise another structure. Let's bring this to mind. Just imagine, say, let's take an example maybe of a president or a minister, or a mayor, having the authority appoints 5 of his children and 5 of his girlfriends to work in the mayoral office. And that is inconsistent with the law. I'm giving a very crude example. Somebody complains and institutes a case before the court. That could surely never ever be an intrusion into executive power. It's an outright illegality. And somebody, the Constitution must ask somebody to do that work. Let me give you another example. No judge can ever make a decision about the budget. Never, ever. In fact, salaries of judges come from Parliament and they're paid out by the executive. And when judges make orders, it's the executive that must implement those orders. So there's been an attempt to try and break up, as I've talked about this already in my lecture, an attempt to try and spread out that. If any judge tried to make a law, if not implicitly, in not an interpretive way as in jurisprudence, everybody will laugh. If a judge tried to pass a statute, that would never happen. If they tried to interfere with the fiscus, there are several judgments in the Constitutional Court. Some were written by me personally. E-tolls is an example where you say you cannot tell the government how to gather revenue. It's not unlawful. They've made a choice and the choice binds us. So in short, we should accept we have devied responsibilities in a particular way. We can go back and say it didn't work too well. And that way is exactly what it is. If any other body, public protector or the IEC or whoever else, all of them are subject to somebody blowing the whistle. And if you don't like judges doing it, then we have to have another structure where you create a structure where other people would make the decision, call them something else and give them the power and say, how do you control? In fact, many other decisions are made that way. Competition Commission makes the decision. There are many other bodies in society which have nothing to do with the judiciary and certainly money and state coercion and the whole range of things that judges have absolutely no power over. And that explains why it was possible for so much money sometimes to be stolen and judges can't stop it. Just a glaring example. So the idea of judicial supremacy may be a valid criticism towards the architecture. But as long as you have a constitutional democracy, the Constitution is supreme. There are people who are going to make judgments on its application, and they are called judges. You are going to find decisions where political actors in particular are unhappy. And sometimes the unhappiness is justified, but many other times it's political speak. In other words, it is a way of saying, back off, I want the open space. And where they've had that open space, just look at the amount of devastation, financial and otherwise. Look how little poor people have got out of the system. All that has nothing to do with judges, and judges have no power over that. So it's a bit of an overstatement to say there's judicial supremacy. Of course, if nobody should keep the executive accountable, I think then we should say so collectively and then change our constitution. Thanks.
Thank you very much, Justice. The next question comes from Itumuleng Chusi, who has asked that Justice Moseneke correctly remarked that our constitution is open-ended and inevitably this provides a room for the so-called shifting of accountability by the state. How does one address this intricate challenge as it has serious repercussions on the realization of socio-economic rights of the poor?
Yes. When I was younger, Itumeleng, I always thought that the law can do everything. Now that I've been in the law for 45 years, I know that the law can only do certain things. You heard in my conclusion, I said that we have set down the parameters on what the executive should do in order to alleviate the plight, socioeconomic plight of poor people in our country. We've said that over and over and over again in jurisprudence. So you must then say, where sits the ultimate accountability? And we saw a bit of it in the last 3 days. Ultimate accountability sits, is electoral accountability, not just judicial accountability. So a people in a nation which has committed itself to play by the rules of the law, so to speak. People go to courts, and that's what this lecture was about. And I show you that the boundaries are not all firm. You're right, Itumeleng. And people have come to court many, many times through various bodies, through activists. The labor movement has come to us often, and so on. But in the end, Parliament divvies out the money to the executive. And the executive has to go out there and implement what they told Parliament they need the appropriation for. And you've heard me say, it doesn't have to be instant. It doesn't have to be immediately. It doesn't have to even to be on the month of the year of elections. The law allows executive to do things subject to available resources and subject to progressive realization. And progressive realization means there must be a plan progressively to realize that particular entitlement. And that by and large has not happened. We know that. So, yes, it is so that the Constitution and the law alone will not be able to achieve those things. And there'll be arguments that we don't have the budget, whatever else. But the truth is, if there's a systematic planning in a developmental state, most of these things can actually be achieved. And if the court's orders do not help in that regard, of course, electoral accountability is very important. The people themselves have to express themselves. I need water. I need proper schools. I don't want pit latrines. I want respect. I ask for respect. I want to be protected from crime. On and on and on the laundry list goes. But courts can't resolve all of those things, even if the entitlements are in the Constitution. And that we have done already. The executive, together with Parliament, having given the money, must go out there and do that. Thanks.
Thanks, Chief Justice. The next question comes from our own Dr. Chieza Zimbo, and it relates to whether nationals from Zimbabwe and Lesotho with a special dispensation permit who are denied the opportunity to apply for permanent residency, whether the judiciary can actually interfere with that executive decision to deny them to apply for permanent residence. So the question is basically whether the judiciary can interfere with that kind of executive decision. But it also goes on to say, can a law stating that Parliament or permanent residency status is a temporary status and cannot lead to citizenship being interfered with by the judiciary? I'm not sure I understand the questions. Can a law stating that permanent residency status is a temporary status and cannot lead to citizenship being interfered with by the judiciary? I'm not sure if you captured the questions, Chief Justice.
I have a gist of what the concern is. If the law is valid, if the law is constitutional and says that you may not derive permanent residency out of temporary stay, and the court doesn't strike the law down, the law is valid, then that is the law. You heard me in my lecture talking about judges being bound by valid laws of the country, because that's the legislative arm of a state. So judges don't wake up and say, yes, all residents, you are now citizens. You'll have to go and look at the law and look at what the law prescribes. How does one become a citizen? If you satisfy those requirements, of course, judges will say you're entitled to permanent residence or citizenship. But if the law says you may not, and the law is valid, in other words, it is not constitutionally defective, then the judge is bound by the law, as you've heard me say. And that's part of the doctrine of separation of powers. Judges don't wake up one morning and say, I want to make everybody a permanent resident. And the reason is, at both a jurisprudential and architectural reason, is the following. Parliament has deliberated and made a decision about who is entitled to citizenship. And if Parliament encrusts that into law, then the courts are bound by that law. They must implement that law. And the courts may examine the law if the law is attacked. But if the law is not attacked and the law is valid, then judges can't change the law. But if the law, if in fact the law allows people to get permanent residence, then the courts will say the law allows it. Thanks.
Thank you, Justice. And the next question is also from one of our Masters of Law students. And the question relates to the possible impeachment of the Judge President of the Western Cape, Judge, and whether, if he is now impeached, what happens to, or found that unfit and to hold office of the Judge President, what happens to all the cases he has presided over and the decisions he has made in his capacity as Judge President? Are those then also affected by this decision now? Because the conduct for which he stands to be impeached happened many years ago.
Yeah, I don't know if you are still there, Professor. Can you hear me?
Yes, thank you. We hear you very well.
Yeah, okay, thank you. Well, you asked me a question which is not my favorite subject. Certainly not my favorite subject to talk about the Judge President of the Cape. I think the matter is currently in the courts, and there is a long, big battle royale around issues of impeachment. And I think the Judge President should have his day in court, and the matter should come to rest somewhere. It has been 12 years now. So I don't want to weigh in on one way or the other, and not in my place to weigh in on the issue. I wish him well, but I think the law must, in the end, the law must win.
Thank you. Thank you, Chief Justice. The next one is just a comment from Mr. Ndando Sindani, basically appreciating an earlier question by Musima relating to the coloniality. So I'm going to just thank Ntando for that comment and skip it and move on to the next question by Tabisa Matsia, which says that what is the justice system's role in preventing the parole board's decision to favorably release certain offenders on medical parole? Over to you, Chief Justice.
Yes, well, you know, we talk about separation of powers, and that's a good question, excellent. There are different bodies in society which do different things. There's a parole board. It has a duty which is set out in a statute. And that board must do its work, right? And must do it in accordance with the statute. If it has acted lawfully, that's the end of the inquiry. And that is true of everybody. It's true of a station commander near where you live. It's true of everybody. It's true of a magistrate who makes a decision. The decision is always subject to review. A judge's decision is subject to appeal. So it's true of everybody in our country. If you make a decision in your parole board, if the decision is done in accordance with the law, there's no recourse. That's the end of the matter. If the person follows the conditions of parole, that's good. And there's no more return to the matter. If that conduct was unlawful, as some people are arguing and have taken it to court, then we have to examine and see whether it was unlawful. And of course, in terms of our constitution, anything that is unlawful is invalid. Just that simple. It's as if you have not done it. So that's what the court will have to examine and make a decision on. I don't know the facts, I don't know, and I can't make a pronouncement on whether it was done validly or not.
Thank you very much, Chief Justice. Let's continue with the next question, and it's from Kabela Ramodola, who says, a follow-up question. Seeing that the baseless accusations of judicial capture are gaining momentum, how best should the judiciary or the government as a whole deal with these accusations so that the public do not lose confidence in our judiciary?
Yeah, well, let me answer the question and we can negotiate time, right? We'd agree to stop at 4 o'clock. It's 7 minutes past 4. Let me answer that first, and then we can. Well, as I said, accusations of judicial capture must be put on the table. Let's examine them. Wild allegations out there, I mean, it's not going to help us. We've dealt with this before. And it's true of any other arm of state. If you say Parliament can't do its work, it's not doing its work because it's captured. It's a nice, I think, accusation to throw around everybody. Gaining momentum, I don't know what you mean by that. But if you know anything, just and I hope they will find people who are non-judges or independent who can sit on that and investigate that. So if you know firm things about gaining momentum is more and more people writing about it on Twitter. No, that's not momentum. Momentum is when you say, look what this judge has done, look what that one has done, look what that one has done. And within the judiciary, there are mechanisms to charge people and to make them to account, and that is necessary. So judges are kept accountable. So if you know something, don't let it go in momentum on Twitter or on political speak. I think you must set out those allegations against me, against anybody else. You must put them down. Clearly, let's examine them and convict those judges or exonerate them. I think that's going to be quite important. But for now, I will urge our people to demonstrate it. If you can't demonstrate it, it's a little like saying, oh, this referee is a Kaizer Chiefs supporter. You can say 10, 100 times, but frankly, you have to demonstrate your allegations against people.
Thank you, Chief Justice. I think we cannot deal with all the questions, but can I just request your indulgence, please, to accommodate Mr. Pohotuna, who raised his hands earlier on.
Yes.
If he's still available, and Mr. Pohotuna, can you raise your question, please?
Thank you so much. It's actually a good thing that one got a chance to wait, to be able to get the depth of knowledge from the justice himself. Justice, I'm just going to speak from a layman's point of view as well, just to maybe poke you, just to get maybe a bit more deeper meaning of this conversation. Chief Justice, the issue of checks and balances when it comes to the three powers, the executive, judicial, and legislature.
Yes.
Which one would you say, given the demographics in our country per se, has more authority or more power? This is in regards to, for example, it was touched with regards to the impeachment, but I want to maybe direct it towards the vaccines in this particular case, in the sense that we are in a democratic state, we've got choices, we can vote, we've got a voice essentially.
Yes.
But now what happens is that we are, in fact, the whole world is being overridden, in the sense that those rights have now been abandoned. And there's a certain power, there's a certain element that's in the air. It can't be pointed, but it's there, because these vaccines have now become mandatory. And should one not partake of that, you are then sort of locked away from society.
Yes. If you are done, Rep or Tuna, I would like to give a stab at that. I'm not sure the connection between impeachment and checks and balances, but in our country, if you want to remove a judge and they have been found to have done something wrong, like if they're found to have been captured, or they've taken a bribe, or they are dishonest in the way they do their work, etc., etc., only Parliament ultimately, sitting 2/3 of both houses, must decide the 2/3 majority that the judge must be impeached. Okay, so it's quite a high level threshold. So it's not going to happen just because some people want a judge to be impeached. That is an example of a check and balance. The judiciary comes and says, one of us has done wrong, we've tried him within the judiciary, and we are unhappy. That person must still, in terms of our constitutional arrangements, that conviction must be submitted to Parliament from the JSC. And Parliament must then deliberate and vote. And 2/3 of them must be satisfied that impeachment must ensue. Okay, so it is something that is important, valuable, and it keeps judges accountable, but at the same time, the power to remove lies with Parliament and not with other judges. Okay, that is a good example of checks and balances. Vaccines, I agree with you. The constitutional judge that I've been and the freedom fighter that I've been all my life, I don't think anybody should be compelled to take vaccines. I don't think it is constitutionally defensible. I've seen some institutions declare very loudly and publicly that nobody will be admitted if they're not vaccinated. And I think time will tell whether, in fact, that is a valid decision. I'm a retired judge, and I don't want to go ahead of myself. But if you ask me, vaccination should be voluntary, and I think the law expects that it be voluntary. Nobody can be compelled to access medical care. Nobody should be compelled. Are there designs and plans and ways in which people are squeezed into that direction? Yes, appears to be so. I agree with you. And I think it's unfortunate. Of course, that's not the only argument. I've seen the argument that if you are not vaccinated, you may pose a threat to the life of others. So it is your life and other people's life. And I think that's what judges will have to struggle with ultimately, balancing out those rights, okay? your right and choice not to be vaccinated against the right to life of other people. We have to show that if people are not vaccinated, they pose a threat of life to others. And that is the evidence that would become important. Having said all that, we know that statistically, vaccination does drop hospital admissions and it does reduce deaths. But even so, I think the decision must be one that everybody wants to take and should be able to take. And I don't know whether you could shut up a public institution, publicly funded by everybody, and say only those who are vaccinated should access education. I don't know whether you can do that. Access public facility and so on. But I'm sure your own university will debate the issue at their own time. This is just a personal view of mine. And I don't think the law will countenance or ought to countenance compulsory. But certainly people should be urged to vaccinate. I'm double vaccinated. And I just think it is safer for me. And everybody should make that decision. Thanks.
Thank you very much, Justice Moseneke, for a very rigorous question and answer session. We will now conclude with the last item on our program, and that is the vote of thanks and the closure. And I call on Judge van der Schuyf, who is our adjunct professor in our School of Law, to please do the necessary in this regard.
Justice Moseneke, all judges present, the Chancellor, Vice-Chancellor, professors and staff members of the University of Venda, all attendees, all protocol observed. Justice Moseneke, thank you. Thank you for sharing your wisdom and insight on such an important theme with us this afternoon. You might not know it and it might be of no consequence, but my background is that I am from academia. And as an academic, I know that once you present a lecture or a paper at a conference, you absolutely fear the question and answer session for two reasons. The first is that you are afraid that you are going to be asked a question that you can't answer. But the second is actually the most important. We are always afraid that we are not going to be asked any questions. Because if nobody asks a question, the big question mark that hangs in the air is whether you connected with your audience. And I think the fact that we actually have to cut short the question and answer session is a testimony to the way in which you connected with each of the 125 plus people who were on the virtual platform. For that, thank you very much. Now, the School of Law of the University of Venda is a worthy institution to be associated with you. In my experience, the staff of the School of Law comprises dedicated, highly acclaimed, and acknowledged academics. This lecture series, associated with one of, if not the most brilliant legal minds of our time, is indeed a feather in the law school's cap. I'm sure that all the students who are in attendance are proud to be associated with the School of Law of the University of Venda. I trust that the students understand just how fortunate they are to be addressed by you. Students, you are the future of our country. Take heed of Justice Moseneke's message and be the proponents for social justice for the future. Justice Moseneke, you are the judicial leader of our time, and history will remember you as such. Thank you for not leaving us stumbling along, but continuing to educate us, even in retirement, through events like this lecture series. Thank you to all the attendees who took time from their busy schedules to attend. It was definitely worth your while. Until we meet again for the second lecture in 2022, may you all stay safe and wear your masks. Thank you.
Thank you.
Thank you.
Thank you.
Well,
Thank you,
I know-
everyone.
I know my time is expired. I just want to thank my judicial colleague, Judge Van Escape. Thank you ever so much for the kind words. And maybe let me say thank you to all of you again. Amazing privilege. Thank you.
Thank you.
Thank you, everyone.
Thank you. Thank you.
Everybody.
Bye. I am gone. Am I allowed to be go now? I may?
Yes, please.
Sure. Thank you ever so
And
much. Sure.
everyone else. This concludes our session today.
Bye, Justice Moseneke.